Name is Rini Natasha, matric number 281123. So I will start with first duties of reporting agency under Anti-Money Laundering Act 2001. The first one is reporting agency has duty on keeping a proper record of the customer and transaction. The reporting agency must keep record of customer identity and transaction to comply with local regulatory obligations. The document can act as evidence if law enforcement conduct an investigation, so they need to make them available. Therefore, the reporting agencies must maintain updated records and regularly communicate with the clients to keep records of updated information regularly. In addition, it is also can be seen easily the in and out transaction of each customer when we have a good record, and it will be a legal evidence when anything happens. The way to keep record of customers such as to make a photocopy of original documents, scan copies or store the documents in electronic form, and the documents should be made available whenever required. However, if the documents are kept in a foreign language, resources must be available to convert them into English for the purpose of easy to everyone to understand what is the content of the documents. The second one is reporting agency also has duty on reporting the suspicious transaction report, which is also called as STR. STR provides the financial intelligence unit and subsequently law enforcement agencies with valuable information or intelligence of potential criminal activities. STR is a fundamental element of AML measures. It refers to a piece of information which alerts law enforcement that certain activity is in some way suspicious and might indicate money laundering and terrorism financing. In Malaysia, the obligation to report suspicious transaction happen when the identity of the person involved in the transaction or the transaction itself or any other circumstances concerning that transaction give reason to suspect that the transaction involve proceeds of unlawful activity.
My name is Nurul Izzati Ayuni binti Ahmad Kamil, matric number 281193. I will proceed with the third duties of reporting agency under AMLA 2001, which is implement AML compliance program. What is an AML compliance program? In order to combat financial crimes, banks, credit unions, and a variety of other financial institutions across the world are required to help and put in place anti-money laundering, which is AML compliance programs. An anti-money laundering program is a set of regulation and procedure that financial institutions follow to prevent and detect money laundering or terrorist financial activities. AML compliance programs are ongoing process is the United States Bank Secrecy Act, which is BSA, has been amended by a variety of subsequently introduced legislation, including the USA Patriot Act, while the EU introduced its fourth Money Laundering Directive in 2017 and its fifth Anti-Money Laundering Directive in 2020. What should an AML compliance program do? In practice, an AML compliance program should ensure that an institution is able to detect suspicious activities associated with money laundering, including tax evasion, fraud, and terrorist financing, and report them to the appropriate authorities. An AML compliance program should focus not only on the effectiveness of internal system and control developed to detect money laundering, but on the risk posed by the activities of customers and clients with which an institution does businesses. Next, the fourth duty is customer due diligence. What is customer due diligence? Customer due diligence is also known as CDD measures. It is an ongoing monitoring, making of suspicious transaction reports, record keeping, risk assessment, and management. CDD also is a process of identifying, verifying the identity of the customer. A reporting institution must be certified that the customer are whom they say they are. Why we do CDD? First is to confirm the identity of the customer. Second, to enable risk profiling of the customer. Third, to prevent abuse by criminals. Fourth, to assist law enforcement agencies. If you are a reporting institution, you will need to conduct CDD when establishing business relationship with a new customer, carrying out any transaction including occasional or one-off transaction, having any suspension of AMLA and TF, also any other condition that the competent authority may specify. Ongoing due diligence applies whenever the reporting institution has ongoing business relationship with the customer, which is customer maintaining an account, repeated customers, and membership programs. There are two main things that there are needs to do for an ongoing due diligence. First, scrutinize or monitor the customer transaction throughout the course. Second, to ensure all CDD information including CDD document is kept up to date and relevant.
Assalamualaikum, my name is Anisha Finas binti Sulaiman. My metric number is 280253. I will proceed with fee duty, which is conducting risk assessment. The first one is documenting their risk assessment and findings, considering all the relevant risk factors before determining what is the level of overall risk and the appropriate level and type of mitigation to be applied. Keeping the assessment up to date through a periodic review and having appropriate mechanism to provide risk assessment information to the supervisory authority. Reporting institutions are required to conduct additional assessment as and when required by the supervisory authority. Reporting institutions should be guided by the result of the NRA issued by the NCC in conducting their own risk assessment and should take enhanced measures to manage and mitigate the risks identified in the NRA. The next 6 duties is reporting of cash threshold report. The compliance officer of a reporting institution that has been granted access to the financial intelligence system and administered by the Financial Intelligence and Enforcement Department Bank Negara Malaysia must submit the cash threshold report through the website. Reporting institution must ensure that the cash threshold report is submitted within 5 working days from the date of the transaction. Submission of cash threshold report does not preclude the reporting institution obligation to submit a suspicious transaction report.
Assalamualaikum and hi, my name is Nurul Fatih binti Azhan, metric number 270061, and for today I will be explaining about another duties of Anti-Money Laundering and Anti-Terrorist Financing Act 2001 or AMLA 2001 under Part 6, which is freezing, seizures, and features of properties. Freezing order. Freezing order is an order issued by enforcement agency under Section 44 of AMLA. It is issued on property of a person who is under investigation with regard to an unlawful activities and where the enforcement agency has ground to suspect either he or she is about to commit an offence of money laundering or terrorist financing, or the property is proceeds of an unlawful activity. A freezing order may even require the owner of the frozen property to surrender his passport to the Director General of Immigration to prevent him from leaving the country. The enforcement agency have to send a copy of the freezing order and the list of the frozen property to the public prosecutor, where a freezing order is made on the money that is deposited in a bank. The enforcement agencies should also send a copy of the order together with the list of frozen property to the Bank Negara Malaysia accordingly. A freezing order is not to be confused with a seize order. Features of the property where there is no prosecution before the expirations of the 12 months from the dates of seize or freezing order. The public prosecutor may apply to the High Court for an order to forfeit the property which has been frozen or seized, even where a person is not prosecuted or convicted for the offence of money laundering under AMLA. If there is no such application, such property shall be released to the person from whom it was seized. The principal purpose of AMLA is used to combat corruption using strict measures including freezing, confiscating, and forfeiting property acquired by corrupt and abuse of power.
Assalamualaikum and hi, I am Nur Mu'aini binti Abdullah. My matric number is 270149. Today I will share with you guys about the duties of Anti-Money Laundering and Anti-Terrorism Financing Act 2001, which are protection of informers and information of money laundering and forfeitures of property upon prosecution for an offences. Protection of informers and information is where a person discloses to an enforcement agency his knowledge or belief that any property is derived from or used in connection with money laundering, or any matter on which such a knowledge or belief is based. If he does any act in contravention or subsection 4(1) and the disclosure relates to the arrangement concerns, he does not commit an offence under that subsection if the disclosure is made before he does the act concerned, be an act done with the consent of the enforcement agency, or after he does the act but the disclosure is made on his initiative and as soon as it is reasonable for him to make it. Notwithstanding any other written law, the disclosure should not be treated as a breach or any restriction on the disclosure of information imposed by any law, contraction or rule of professional conduct, and he should not be liable for damage for any loss arising out of the disclosure or any act done or omitted to be done in relation to the property and consequence of the disclosure. Where any information relating to an offence under this Act is received by an officer or the competent authority or reporting institution, the information and the identity of the person giving the information will be secret between the officers and that person, and everything contained inside information, the identity of the person, and all other circumstances relating to the information, including the place where it was given, will not be disclosed except for the purpose of subsection 8(1) or section 40. Next, forfeiture of property upon prosecution for an offence. Subject to section 61 in any prosecution for an offence under subsection 4(1) or a terrorism financing offence, the court will make an order for the forfeiture of any property which prove any property is proved to be the subject matter of the offence or to have been used in the commission of the offence, or which is proved to be terrorist property, where the offence is proved against the accused or the offence is not proved against the accused but the court is satisfied that the accused is not the true and lawful owner of such property, and that no other person is entitled to the property as a purchases in good faith for valuable consideration. Where the offence is proved against the accused but the property referred to in subsection 1 has been disposed of or cannot be traced, the court shall order the accused to pay as a penalty a sum which is equivalent to, in the opinion of the court, the value of the property, and any such penalty will be recoverable as a fine. In determining whether the property is the subject matter of an offence or has been used in the commission of an offence under subsection 4(1) or a terrorism financing offence or is terrorism property, the court will apply the standard of proof required in civil proceeding.